as I said, we'll move straight on now to, we've saved a great treat, saving our special address to mark the 25th anniversary of the Samuel Griffith Society. Those of you who noted that Keith was wrong, that John Stone did in fact deliver a welcome to country, might want to go and quickly change your bets on the McGregor Mayflower bout. For the rest of us, I think what Adam Smith once said, I think summing up what your point at the end, that virtue is more to be feared than vice because its excesses are not subject to the regulation of conscience. So without more to say on that, the Honourable Nicholas Hasluck will do us the honour today of giving the 25th anniversary address to the Samuel Griffith Society. Once again, a man who genuinely needs no introduction to this audience. And he was born in Canberra. Don't hold that against him. He is, of course, a genuine son of Australia, and he was in Canberra because his father served this nation with such great distinction, rising to be one of our greatest Governor-Generals. He himself, of course, is a Queen's Counsel, was President of the Equal Opportunity Tribunal, a Judge of the Supreme Court, and for me, a brilliant writer, and one who's been recognised not just with a Premier's Literary Award, but with an award from The Age. So a man who obviously can reach across the political spectrum with his insights and be recognised by all of us as indeed a great writer and a great Australian, and it gives me great pleasure to introduce Sir Nicholas Hasluck.
Thank you for that generous introduction, Rebecca, and good morning to you all. Now, my time is limited, so I'll go straight to it. As you know, the conference marks the 25th anniversary of the Samuel Griffith Society. It was founded in 1992, and the inaugural conference of the Society was held in Melbourne in July of that year. Some months later, my father, the late Sir Paul Hasluck, was invited to launch the proceedings of the inaugural conference. Unfortunately, he was unable to launch the book in person due to what proved to be a terminal illness. I was therefore delegated to present the address he had prepared, and did so on 25 November 1992 at a dinner in Perth, very close to where we are now assembled. I felt privileged to have had this personal involvement in the early days of the Society, and I feel immensely privileged to be playing a part in these proceedings 25 years later. I salute the Society and its supporters for the splendid work they have done to encourage a wide understanding of the Commonwealth Constitution and our national achievements under it. It gives me particular pleasure to see John and Nancy Stone back here in Perth, and a pleasure to be, in effect, sharing a platform with John this morning, and especially in the light of his profound and compelling paper, if I may say so. Now, on this occasion, I was invited to speak on a topic of my own choosing. As I dwelt upon the early days of the Society, I was drawn back to John's foreword to the inaugural book, in which he noted that the chief purpose of the Society is to ensure that if any changes are to be made in our Constitution, they should only occur after the widest range of thought and opinion has been canvassed. This took me inevitably to the current push for recognition of Indigenous Australians in the Commonwealth Constitution, and to my father's time as Minister for Territories in the Menzies government. In Shades of Darkness, his autobiographical work covering his involvement in Aboriginal affairs over 40 years, from 1925 to 1965, first as a journalist and social reformer, then as a politician, Paul Hasluck confirmed that an earnest effort was made to change Australian indifference towards Aborigines, to improve their conditions and to raise their hopes for the future. He said, "We strove for the full recognition of their entitlements, legally as citizens, socially as fellow Australians." It struck me that it might be useful to evaluate current proposals for constitutional recognition in the light of those words. I'm conscious, of course, we've had some able and some full discussion of the issue this morning, but I hope that I will be adding something to it. Now, briefly to recap what we've heard, there have been various proposals for recognition in recent years, ranging from statements of fact for inclusion in the preamble, the removal of references to race in certain substantive provisions of the Constitution, and even to proposed new clauses rendering discriminatory conduct unlawful. It now seems, however, in the aftermath of the Uluru Convention and the final report submitted to the Turnbull government by the Referendum Council, that the proposals mentioned earlier have been replaced by what one council member called a relatively new development, namely that the Constitution should provide for a representative body that gives Indigenous people a voice to the federal parliament and the right to be consulted on matters that affect them. The details of this proposal have not yet been worked out, as we've heard from the earlier speakers, and that notwithstanding after widespread consultation with Indigenous delegates. This has caused concern. Labor MHR Linda Burney described the Referendum Council's recommendations as limiting and as providing no clear line of sight to a referendum. Liberal MHR Ken Wyatt observed that a representative body of the kind proposed need not be enshrined in the Constitution, but could simply be enacted by legislation. Labor Senator Patrick Dodson called the proposed body a bolt in the dark. He said that the whole thing seemed to be, quote, going round in circles. This took me to the concise Oxford Dictionary and the word roulette. It means gambling game on table with revolving centre. I have called this paper Recognition Roulette. The title evokes the elements of chance and uncertainty hovering over the Referendum Council's report. I will enlarge upon my criticisms in due course. They go to a paucity of consultation with the general public and the prospect of disharmony of a special entitlement based upon race as entrenched in the Constitution. Before looking at these matters, however, I must turn to a fundamental objection, namely that an Aboriginal advisory body will complicate and eventually erode the structure of responsible government. My objection is illustrated, interestingly enough, by some controversial events in the history of Western Australia, where an ill-fated attempt was made to confer special entitlements upon the Indigenous people of this state. For the sake of historical accuracy, I will use the language of the colonial era, although I am conscious, of course, that certain terms are now being questioned by contemporary commentators. The word Australia first appeared in the Imperial Statute Book in the Act of 1829, providing for, quote, the government of Her Majesty's settlement of Western Australia on the western coast of New Holland, unquote. It appears from Paul Hasluck's seminal work, Black Australians, a survey of native policy in Western Australia published 70 years ago, that in the absence of any specific instructions concerning the Indigenous inhabitants of the new land, the first Governor, James Stirling, simply reiterated the principal protection applicable in other colonies. The rights of the Aboriginal people as British subjects were fully acknowledged. The steps by which Western Australia achieved responsible government under the Constitution Act of 1889 mirrored the process followed by the other Australian colonies. However, in the end, unlike any other Australian colony, the state's new constitution included a special provision in Section 70 placing Aboriginal inhabitants of the colony under the care of a board independent of the local parliament. An annual grant equal to 1% of the colony's gross annual revenue was to be passed to the Aborigines Protection Board for the welfare of the Aboriginal natives and, quote, the education of Aboriginal children, including half-castes, unquote. Section 70 was entrenched by manner and form provisions. It could only be amended or repealed with the approval of the British government. These arrangements were inconsistent with the usual conventions concerning responsible government and suggested that ministers in the colonial government couldn't be trusted to deal with Aboriginal people fairly. The elected government had no control over funds set aside for Aboriginal welfare. There was no clear link between the 1% of gross revenue formula and the needs of the Aboriginal people. In due course, after considerable agitation in the colony about these matters, Section 70 was repealed by the Aborigines Act of 1905 with the approval of the British government. Contrary to what the Chief Justice said yesterday, it wasn't an act introducing a system of apartheid, it was an act providing for native welfare along the lines of the constitutional provision, but without the 1% formula. Since that time, funds for Aboriginal welfare and policy have been subject to ministerial supervision in Western Australia in a manner consistent with responsible government. In the post-war era, critics of governmental policies, such as the white activist Don McLeod, queried the repeal of Section 70, but the High Court has now held in Ugala's case that the repeal effected by the 1905 Act was valid. Legal opinions have established that steps related to the repeal did not give rise to any actionable breach of duty. The Section 70 controversy must now be seen as part of a broader social and political picture, a scene that has been transformed by a range of different policies and practices over the years and by allowance for native title to land in the aftermath of the High Court's decision in Mabo. Nonetheless, this ill-fated attempt in Western Australia to create a protective clause for the benefit of Aboriginal people in the Constitution of Western Australia points to significant flaws in the Referendum Council's current proposal. I will deal with each of these in turn. First, an obvious point. Changing times weigh against constitutional provisions designed to effect social improvements. The 1889 Section 70 provision was designed by idealists in London with a virtuous belief that something had to be done to improve the situation of Aboriginal people. A supposedly enlightened view was then entrenched in the Constitution, but without any clear plan of action as to what exactly should be done, and contrary to the usual rule of responsible government. A figure of 1% of the state's gross revenue was simply a rough guess as to the amount required. It was quickly overtaken by a changing economy and other significant events, including the influx of t'other-siders during the gold rush of the 1890s and a commitment to the federal system created by the Commonwealth of Australia Constitution Act of 1900. The policy of protection, reflected in the name of the board appointed to distribute the special funds, was superseded in due course by the move to assimilation, the idea that Aborigines should have the same rights and opportunities as other Australians. Some years later, the policy of assimilation was denigrated as paternalistic by would-be reformers. It was supplanted by a miscellany of policies echoing the international emphasis upon self-determination for Indigenous people. figures cited by the Chief Justice yesterday suggest that this policy in turn is not the panacea it was supposed to be, and now some other policies may be needed. This kaleidoscopic series of events suggests that any attempt to create a special constitutional entitlement for Indigenous people is fraught with hazard because social conditions and proposals for improvement are constantly changing. Nor can it be said with any confidence that the hardship which Aboriginal people in the West undeniably experience would have been removed or even substantially alleviated if the Protective Board and Special Fund had operated in the manner envisaged by the Section 70 provision. The governance of Indigenous affairs has proved intractable from one generation to the next, and the funding provided never seems to be enough. This is undoubtedly because administrators in every era, including Aboriginal leaders on land councils and other bodies in contemporary times, have been confronted by certain fundamental issues which have never been satisfactorily resolved. These basic issues were summarised by Paul Hasluck in his book Shades of Darkness. Whether Australians of Aboriginal origin are to live together with other Australians or apart from them. Are they to have the same opportunities or different opportunities? Are they to bear the same responsibilities and be subject to the same laws? Is Australia to have one society or two societies? Did the Referendum Council give sufficient weight to the presence of these fundamental issues and to criticisms of the kind that led inevitably to the repeal of the Section 70 protective clause in Western Australia I mentioned a moment ago? According to the co-chair of the Council, Mark Liebler, various, quote, Indigenous-designed, unquote, dialogues culminated in the National Constitutional Convention at Uluru in May 2017. This led to the making of the Uluru Statement from the Heart, which favoured the advisory body idea. As we've heard, it called also for the creation of a Makarrata Commission to supervise the making of treaties with First Nations and with provision for truth-telling about the dark side of Australian history, Aboriginal dispossession. The Referendum Council was not in a position to make a specific recommendation about the Makarrata proposal because it lay outside their terms of reference. The Council, as we've heard, made the single recommendation that there be an advisory body giving Indigenous people a voice to Parliament. The co-chair acknowledged that, quote, there's significant work to be done to flesh out the details of how a constitutionally enshrined body would operate, unquote. In addition, a declaration articulating Australia's shared history, heritage and aspirations would be enacted by parliaments across Australia. The unfortunate history of the Section 70 protective clause in Western Australia shows that idealism is not enough of itself to quell all doubts about the wisdom of creating a special entitlement within the framework of a democratic constitution, especially an entitlement based upon race. Nor is it enough to point to a consultative process shaped essentially by the prospective beneficiaries and their friends. The Council's report says that the general public were encouraged to share their views through our digital platform. This is nonetheless, as Council member Amanda Vanstone noted in her qualifying statement, the consultative process cannot be said to have captured the imagination of the broad Australian community. This is probably because the idea is new and the details haven't been worked out. Australians, Vanstone contended, need to see a largely agreed plan as to what they would be voting for in the first instance. And yet, in a sabre-rattling tone, Mark Liebler has announced that there is really only one way for our leaders and our nation to respond to the report, that is, quote, to accept the destination and work together to chart the best course to get there, unquote. Unlike the Aborigines Protection Board in the ill-fated Section 70 provision, it seems that the proposed Aboriginal body would not be administering policies or related funds. Its role will be supposedly limited to exercising its right to be consulted in matters affecting Indigenous people. Several widely respected commentators, including our speaker at last night's dinner, have suggested that in the absence of a right to veto legislation, the advisory body proposal is a comfortable fit with the structure of responsible government. They seem to envisage that this quasi-parliamentary body will simply make useful recommendations to the government of the day and quietly abide by whatever resolutions are passed by the Parliament in Canberra. Like John Stone, to my mind, such a view is unrealistic. The advisory body has been described by its proponents as a means of empowerment and not as a shield, but as a sword. So long as the fundamental issues I mentioned earlier lie unresolved, the proposed advisory body will become a lightning rod for debate about a vast array of current policies. Some of these, no doubt, will fit the co-chair's description of matters that affect Indigenous people, for example, the provision of services in remote communities. Others will be debatable, especially where people claiming to be of Aboriginal descent are living in urban areas in much the same way as other Australians and with declining links to Indigenous traditions. The report concedes that the concept of providing advice on certain matters requires definition, and seems to accept that some laws of general application may well be interpreted as having an impact on or significance to Indigenous peoples. In other words, it may turn out that nearly every matter of current concern is seen as having an Indigenous component of some kind. The inability of federal governments to govern decisively, often due to the vagaries of crossbenchers in the Senate, is a constant problem these days, as Tony Abbott noted yesterday. I doubt that voters will be pleased to see the structure of government burdened by a new advisory body which, pursuant to a constitutionally entrenched mandate, may claim the right to talk incessantly about matters of interest to it, causing further indecision and delay. It may become, to use Amanda Vanstone's words, an inbuilt dissonance within our system. It is true that in the case of the Aboriginal Protection Board, the frustration felt by the elected government in Western Australia was exacerbated by the fact that the board was entrenched by the authorities in London as a caveat upon the grant of responsible government and in a manner that was thought to be coercive. It might be thought if the proposed advisory body is approved at a referendum, then such a criticism referable to outside interference would be removed from the equation. I admit the force of this argument in logic, but I doubt that logic will be sufficient to override any deeply rooted controversies in which the government of the day is seen to have no control over a quasi-parliamentary body with its own constituency, and especially if doubts arise, as they have in the past, as to the range of people being described as Indigenous. The language used in the ill-fated section suggested that over a century ago the term half-caste was thought to mark the outer limit of Aboriginality. That term was thought too restrictive by changing policies and is now seen as offensive. The range of eligibility has been opened up and is steadily expanding. A recent Australian Bureau of Statistics report noted that a 93,000 increase in the count of Aboriginal and Torres Strait Islander people between the 2006 and 2011 census was larger than can be fully accounted for by natural increase and migration. 70% of the increase was due to natural population increase. The remaining 30% increase was due to an increased propensity for people to identify themselves and their children as being of Indigenous descent. This propensity will complicate the work of an advisory body. The consultative process hosted by the Council has created another complicating factor, the advisory body proposals being presented to the nation in conjunction with talk about Makarrata and the making of a treaty, or perhaps many treaties. The former Prime Minister John Howard noted some years ago that the indivisible nation of Australia could not make a treaty with itself. Discussion since that time seems to have led to a more flexible usage in which the term treaty has been equated to other forms of agreement between independent parties. Whatever the usage, the term suggests separate development of some kind. In these circumstances, it is not surprising that some commentators have seen the push for a treaty or series of treaties as essentially a stalking horse for an eventual claim to sovereignty by Indigenous communities. Treaty talk is divisive. The preamble asserts that the Constitution of the Commonwealth of Australia is founded on the will of the people whom it is designed to unite and govern. The word constitution in this context connotes the idea of a fundamental law couched in general terms, a law which is not easily changed, although social habits and policies for improvement may change. It differs from a treaty because an agreement between independent regimes is terminable at the will of the parties involved. The Australian Constitution, on the other hand, was designed to endure and is binding on every member of the community. As a consequence of statutory reform since the Constitution was enacted, Indigenous people now have essentially the same status as other citizens. The handicaps which they continue to suffer today are social rather than official. It follows that what is proposed by way of recognition, the setting up of a quasi-parliamentary entity, can best be effected by statute, not by constitutional amendment, if indeed after wider consultation it is seen as useful. This would at least avert the risk of creating a permanent forum for dissension based upon race. Is the proposed advisory body likely to be of any real use? Policies come and go. Missionaries are replaced by anthropologists. Descriptions of identity are varied and expanded. Proposals for recognition are canvassed and rejected. There is talk of treaties while solutions to fundamental issues are pushed back and forth. There is indeed a sense of things going round in circles, as Senator Dodson noted. This suggests that the process of recognition is still evolving, and it would therefore be very unwise to have a potentially divisive proposal crystallised in the Constitution at this moment. At a time when public opinion seems to be sympathetic to Indigenous aspirations, as some discussion has noted, the energy of those involved would surely be put to better use by looking for answers to the fundamental issues mentioned earlier. It may well emerge from a broader consultative process that these aspirations can be achieved by constructive collaboration on all sides. There may well be support for Indigenous aspirations within the general community, so long as they aren't obscured by divisive talk about swords or treaties or claims to sovereignty. The reality is that the aspirations of the Indigenous people can be achieved within the framework of the Constitution in its present form, and they seem to be compatible with the aspirations of the Australian people as a whole. I near the end, but let me say this, that the former Minister for Territories, Paul Hasluck, completed Shades of Darkness by saying that in the 1950s, as I've noted, he and his contemporaries strove for the full recognition of the entitlements of Aborigines legally as citizens, socially as fellow Australians. It is consistent with that objective and pleasing to note that the first Aboriginal member of the House of Representatives, Ken Wyatt, was elected in the seat of Hasluck. He has been joined in the federal parliament by Senator Dodson and Linda Burney. They and others like them in times to come in the parliament and in the professions will be a voice for the Indigenous people, a voice to speak of their stake in the future and of a people who love their land. voices to Parliament of this kind will do more to advance the Indigenous desire to hold our traditions while embracing the future than the creation of an extraneous advisory body bogged down in debate fostered to a large extent by international ideology. Australians of goodwill can probably be persuaded to support a case for change they understand, but they are bound to reject a claim that smacks of special privilege or coercion, or is tainted by virtue signalling and a sanctimonious tone. The future will be a troubled one if we do nothing but assert rights against each other and forget our common responsibility to work for a common future. Law must ultimately be tailored to the society it serves. It follows that would-be law reformers should always keep in mind not only the entire range of Australian history, Indigenous and non-Indigenous alike, but also the strengths of their own system, including the Westminster style of government. In our haste to atone for past wrongs, we must not forget that we are still part of Western civilization. I began by acknowledging the achievements of the Samuel Griffith Society over the past 25 years. I've sought to underline this point by drawing upon the works of a social reformer who was not actually present at the creation of the society, but was close enough to its beginnings to have had a few thoughts for a better ordering of constitutional affairs. With these thoughts in mind, let me close by quoting a passage from Paul Hasluck's autobiography, in which he speaks of his understanding of men and women of all races who love their land and are comforted by memory of their own past. He said, "In love of our own country, each of us realizes a common humanity coming from deep wells. Patriots are only understood by patriots. A feeling for one's own country is the clearest way to feel deeply for men and women in other countries. The folly and the failure of so many internationalists comes from the fact that they lose sight of the true goodness in other countries when their senses are blunted to the goodness of their own." Thank you for your attention.